So estate planning is not just about what happens to your stuff after you die. We also look at times that you are incapacitated and unable to make decisions for yourself. In those cases, we want to authorize someone to make certain decisions on your behalf when you cannot do so. Now, imagine a situation. You're headed to a Taylor Swift conference. You're 30 years old, you're driving down the road, going to a Taylor Swift conference, and a drunk driver comes careening in front of you. You slam on the brake, the drunk driver misses you, runs into a telephone pole. The telephone pole falls down in the way of a biker. The biker hits the telephone pole, flips through the air, lands on a hot dog stand. Boiling water is flying into the poor bicyclist's face. They get up there running around, clawing at their face because it's melting. And all of a sudden, a bus driver where the bus is full of individuals with special needs and nuns, sees the bicyclist running around clawing their face, slams on the brakes, vomits because of the scene, and rolls out of control, hits a building. The bus lights on fire. You heroically jump out of your car, run into the bus, save all the nuns, save all the individuals with special needs, carrying out a young child that is chair bound. You're carrying the wheelchair with you because you're just that amazing. You step on a rock, fall down, hit your head. Lightly, it just grazes you. But when the medics get there, they say, we should take a look at that. They take you to the hospital. They say, we're going to keep you overnight to make sure that there's not a concussion. They give you Jell-O. The Jell-O is made with jackfruit. You've never had jackfruit. It sounds and tastes pretty good. You try it. Unfortunately, you have a terrible allergic reaction to it and go into a coma. Who's going to handle your financial affairs in this situation? If you've done your planning, it'll be your attorney-in-fact under a durable financial power of attorney. My name is Gregory Singleton. I'm an attorney with Signature Law. We're here to talk estate planning. It's part of our Essential series. Today, we're going to look at the durable financial power of attorney. This is part 1 of 2 videos. So let's start with what is a durable financial power of attorney. It's a document that authorizes someone to step in your shoes and make financial decisions on your behalf, usually when you're unable to do so yourself. Durable means it's effective while you're incapacitated. It doesn't mean it's effective only while you're incapacitated. It just means it retains its effectiveness while you're incapacitated. If it's non-durable, that means it loses its effectiveness as soon as you are unable to rescind it. For estate planning purposes, we generally want a durable one. There's a number of people involved, well, really 2 people involved. There is the principal. They are the individual that is drafting for which the attorney-in-fact is granting authority. They're the ones granting authority to the other person, their agent, which is called the attorney-in-fact. The attorney-in-fact is the one that is the fiduciary that is granted the authority to make certain decisions. Notably, it doesn't need to be an attorney at law, we call it attorney-in-fact because of stuff. They are a fiduciary, meaning they have to act on your behalf, even if it is against their own interests. In Minnesota, there are 2 types of durable financial power of attorney. There is the statutory short form power of attorney, and there is the common law long form power of attorney. And today, we're going to look at each and see what they are, some of the pros and cons of that. And then in next video, we're going to look at some strategies for approaching your situation and in determining whether you should have a statutory short form power of attorney, common law long form power of attorney, or a mix of both. Let's start with the statutory short form power of attorney. So what is it? Well, very simply, it is a statutory form. That is a power of attorney. Just like a power of attorney, but you have to follow the statutory form to the letter. Now, the benefits of this is financial institutions are obligated to honor the statutory short form power of attorney. If they choose not to, they can be subject to all sorts of fines and stuff. The other benefit is that they're incredibly popular, meaning that they're commonly used and they're often rubber stamped by financial institutions because they know what they're looking at. There's no surprises. They don't have to weed through a bunch of creative language drafted by an attorney. Now, the downsides of the statutory short form power of attorney is that they are non-negotiable instruments. You cannot change anything in the form. So if you start changing the terms, if you start changing the authorities, you all of a sudden no longer have the protections of the statutory short form power of attorney. In fact, it turns into a common law power of attorney. Now, the powers that are granted by a statutory short form power of attorney are broad. There are 13 enumerated powers. Most people just select all of them. But if you look at the powers, they're very simplistically drafted. For example, it'll say banking transactions. What is a banking transaction? Does that mean making deposits, writing checks from things? Does that mean closing down your bank account? You cannot define what banking transactions means. You can't say only banking transactions at Acme Bank. You can't do that. Otherwise, you no longer have a statutory short form power of attorney. Also, you can't negotiate or custom tailor the authority of the statutory short form power of attorney. For example, once it is signed, it is effective immediately, meaning your attorney, in fact, has authority to do everything under the statutory short form power of attorney. One of the things that you can't do is you cannot redraft it to make it springing, make it effective only upon your incapacity. Once you draft that document, it's there. Now, the common law power of attorney or long form power of attorney is a power of attorney that is drafted under Minnesota law that basically doesn't follow the statutory form. It could make a small change from it, or it could make a dramatic change from it. In any event, it doesn't follow the statutory form. It doesn't have the protections of the statutory short form power of attorney. And the big downside to this is that you lose the protections of the statutory short form. A financial institution can actually reject it, which is a very scary situation if you're in the hospital in a coma and your attorney in fact is not allowed to write certain checks. Now, the benefits of the common law power of attorney is that it is completely custom tailored, or it can be. You can make it springing. You can define what banking transactions are or personal property transactions are. You can say it's only for certain banks, it's only for this, only for that, and you can limit things down or make it as expansive as you want. You can actually add in authorities that are not included in the statutory short form power of attorney. So in next video, we're going to talk about how to approach the issue of durable powers of attorney and whether you should have a statutory short form power of attorney, a common law long form power of attorney, or a mix of both, depending on your circumstances. But there are two things that I really want to touch on before we go today. First of all, the durable power of attorney is an incredibly powerful document. If misused, your attorney, in fact, could clean out your bank accounts, clean out your retirement accounts, sell your house while you're sitting at your kitchen table, go to Vegas, put it all on Red 13, and you'll probably never see your money again. Even if they win, ain't gonna win and get it back. So most importantly, pick only people that you trust to be your attorneys, in fact. Don't pick someone that you're unsure about. The second thing that I want to touch on is just make sure you do it. Durable powers of attorney are really, I would say, inexpensive and reasonably priced, anywhere from around $100 to a little bit above, a little bit below. It depends on the attorney you go to. But if you don't have a durable power of attorney in your place, and you do go to a Taylor Swift concert, and you do go into a coma, all of a sudden your friends and family are going to have to go to court to get a conservatorship hearing. And conservatorships are extraordinarily expensive, many thousands of dollars, and it takes several months to get the conservatorship in place. So by avoiding spending $100, all of a sudden you are putting your friends and family in a place where they have to spend thousands, and you're suffering in the hospital, not being able to get things paid for weeks, if not months, while that conservatorship is in place. So powers of attorney are a vital part of our estate plan. Don't overlook them. In my experience, the times that people have come to my office and said, hey, my friend just developed dementia, they no longer have capacity, but they don't have a durable financial power of attorney, I need it. I can no longer count those situations on one hand. That's a scary situation, and we don't want it. So just make sure to get your durable power of attorney in place. And there you go. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. We do a new video every other Wednesday. If you have questions, leave them in the comment below or send me an email. Either way is great. I'll get back to you. Otherwise, until next time, this is Gregory Singleton with Signature Law.